Good afternoon, Your Honor, and good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Robinson. Mr. Robinson, if you're not muted, can you state your name for the record?
Martez Robinson.
Thank you, Your Honor.
This is defendant's motion.
Yes, yes, it is, Your Honor. May it please the
Go
court?
ahead. Yes.
Thank you. Your Honor, this afternoon, and although we started this morning, this afternoon, I'm asking the court for a bond in this particular matter. I believe that it is a denial of his rights to having bond. I understand what Sister Counsel has written, but what I would draw the court's attention to and make note of, because I believe that the court has a grasp of what we're asking for, but I look at where the prosecution wants to make an assertion where at the onset of this case, at the arraignment, we didn't identify that there's any differentiation or failure to make an identification of the parties, the involved parties in this matter. But what I did say was there's an element of self-defense in this particular case. Nonetheless, that shot being put over the bow, the prosecution wants the court to assess an unfair burden, which I believe in number 11 in her response, she indicates, however, the defendant made no statement to the police. That would eradicate his rights to Fifth Amendment right and any rights that he would have to counsel before making any statements, or if he did make any statements. So that's one aspect of where I think that the prosecution's asking the court to be unfair and hold him to an unfair burden. Now, if the court would allow me, I don't know if I have sharing privileges. It appears as I do, but I would. And what I do have before the court is, this is his lawsuit. This is, and I brought that up during the arraignment because he's charged with fleeing and eluding. He himself, when his vehicle came to rest, where did it come to rest at? It came to rest at the Washtenaw County Jail. That's where he was on his way to. He was on his way, and the entire time while he's there, or I won't say necessarily the entire time, he's on the phone with his mother. So now, to the extent the court would like for me to produce those records, I'll produce them. But again, this is an individual who has a definite fear of the police. Now, the prosecution wants to say the fact that case from 2015 was dismissed and offered reasons why it's dismissed. I'm showing you why it's dismissed. I'm showing you the federal lawsuit that was filed on his behalf. And I can also offer, as an officer of the court, that there was a settlement in this case that was somewhere south, a little bit south of $50,000. No, this is the reason why. And to that extent, what they want to draw is some assessment or have some negative assessment towards Mr. Martez Robinson as it relates to that particular action that took place, I think, in 2014 or 2015. But this is the result, and this is what happened, and this is what we do have a record of. Whereas that case didn't proceed, that case ultimately was dismissed. This case was dismissed, but it was dismissed as a result of a settlement. And notwithstanding that officer not being available, I believe that officer was available for depositions in that particular case. So I offer that to the court. So where we are is, if to the extent that there is, and I would draw a discrepancy that and I use the term discrepancy because Ms. Blanche she's a great officer of the court. But we see things differently. I don't see this individual, Mr. Robinson, as having come to the decedent's place of residence. That's not the decedent's place of residence. That's the decedent's, that is Mr. Robinson's ex-girlfriend or ex-fiance. They have two children in common. That is her home. That is a home in which this individual wasn't a resident of her home. But he came to that particular location. So to suggest that Mr. Robinson left his home, and what I would indicate to you, my client, he's been employed since I believe 2017 or 2018. He's on his way to work. So on his way to work, this undertaking took place, and he was working from 2 p.m. until 10 a.m. that day. He goes in, and this event unfolded. So to suggest that he simply left his house, armed himself, left his house, and went to this other individual's house, that other individual, I think the prosecution is saying is the decedent, is an inaccuracy. It's just not, it's not true. And I understand where the prosecution may make that assessment that that's his house, but this is an individual who has, I understand that'll play itself out in just one moment. I'm sorry, Your Honor. Oh, I'm just and that's a matter that'll play itself out in court. But this is an individual that should be entitled to a bond. I understand this bond, it may be significant, but there's clear, as we say, self-defense, that can't be, as much as there may not be much to go on as far as that is, but as an officer of the court and in telling the court that there's going to be self-defense in this particular case, you know, how much it is, it's the same burden, the same way that we should look at where the prosecution wants to assess that that guilt is evident or the presumption is great. It's not. What we have, as I said, is a shooting that took place, and that's all we have. And to cast it into something else is the prosecution's, quote, spin on this. You know, the pejorative term would be spin as it relates to the circumstances that unfolded on that unfateful morning. But to suggest otherwise and to deny this individual a bond, I believe would be a miscarriage of justice. So I'd ask the court to consider that, and I'll leave save any opportunity for rebuttal.
Ms. Bunch.
Judge, the only reason why I've made any said anything about the defendant not making a statement is because part of the police report, we don't have a statement from the defendant. So obviously I don't know what's in his mind. They've claimed self-defense at arraignment, but there's nothing in the police report that supports some type of self-defense claim. I was asking to deny bond based on the facts that we have in the police report. We have an eyewitness who saw the defendant crouching by a car, said it was like my kids were playing Call of Duty or something, the way he snuck up between the vehicles and he had a gun, was right there. He was shouldering a rifle. It was a longer gun. It wasn't like a pistol or a handgun. She said that he crouched over like he was trying to sneak up on them. And the next thing she heard was him say to the victim, "Give her fucking keys, bitch." When she saw him raise the gun, she ran to the bathroom, called 911, and she hears a gunshot. And then the next thing she sees is the victim laying on the ground and Alicia providing CPR to him. So then he leaves the area, the police come, they see him leaving, they go after him, and he spends 25 minutes on a flee from the police. And they're saying that was because there's a prior, a prior lawsuit from 2013, 2014. And that's why he didn't want to pull over, because he was scared of the police. That was with IPSI, that wasn't with the Washington County Sheriff's Department, but I still get it, it's police. But at the same time, he has had police contact multiple times since 2013, 2014, which didn't lead into any type of flee. In fact, he was pulled over for a traffic offense in Detroit in 2016. In 2018, he was pulled over by IPSI, who he had the suit against for no proof of insurance. He has a 2017 OWI out of Plymouth, where he was pulled over and was possession of a firearm, which he didn't flee. So he didn't flee on any of those incidences. So to make the argument that he fled from the police in this particular incident after he shot somebody because he was scared because of the lawsuit, I believe is disingenuous. He is a flight risk. He shot and killed a human being. We have eyewitnesses who have recounted that. And he is not supposed to be contacting her in jail. She's one of our main witnesses. I would ask that to stay in order. And I ask you to deny bond based on the fact that the swear to was done before the judge. She got to read the whole entire police report. She heard arguments from both sides, and she made the determination at the time that the bond should be denied in the case.
May I, Your Honor?
You may. Thank
you. May it please the court. So what prosecution is not telling you is during this circuitous route through the streets of the city of Ypsilanti, Mr. Robinson is going 20 and 25 miles an hour. At some point, he's going 40 miles an hour. He's not fleeing. We forget that he arrives and his car rests.
So I guess I have a problem with your argument, because you're telling me that he was headed to basically the sheriff's department because he was scared of police. Mm-hmm. And what about these other stops?
Well, I understand.
You may sit there and argue about how fast he's going or what he's doing, but what about these other stops from his lawsuit? I mean, that You shared the screen to show me this lawsuit,
Right?
saying he's scared of police. Now you want to minimize what he was really doing on that day. Why didn't he just pull over?
Well, Your Honor, I'm not saying that this is not an emotional event for my client. I'm not saying all those things. I'm talking about the infusion of several different factors that you have there. It's late at night, and but ultimately, we can't escape the fact that where this vehicle came to rest is at the Washtenaw County Jail. That is the story. I understand that he's had these other stops and these other arrests, but we can't forget the emotion that's fitted in here. Furthermore, as it relates to the witness who claims to have seen, that witness is not claiming to have seen what actually transpired. That witness is not claiming to have seen what police discovered is that decedent had a firearm. That decedent, a felon who just got out of prison, or was on, I don't know if he's on parole, but has got out of prison for weaponry, who also has a plethora of information throughout social media, which now under Rule 405 will come in this particular case about his propensity to have firearms or propensity for violence, as he allocutes on his own in his videos and suggestions and rants throughout social media. But more importantly, that individual there was a firearm that was right next to that individual, and understanding that firearm does not declare to have been fired, but there is in this case built in that self-defense element right there in and of itself. So again, the things that are not known today is still, I believe, he should have a bond, and not to mention the fact that this individual, he presents himself today as a father of 2 children, 1 stepchild, working, and he has one prior offense, which is the OWI that prosecutor spoke of. This is an individual that should be entitled to a bond. I think the factors bear itself out. And to the extent that prosecution wants to say, well, he was arrested here, or not arrested, but he was stopped here, he was stopped there, it doesn't merit. It's like comparing apples to oranges. We recognize what just happened, and this individual, through his efforts, is trying to get to the Washtenaw County Jail, which is where he ultimately came to rest. He's not a flight risk. This individual was turning himself over to custody. The fact that he didn't make a statement, he recognized, hey, I have a right not to make a statement. So again, as his counsel, as an officer of the court, we're talking about a self-defense.
Anything else?
No, Your Honor.
All right. The court doesn't believe that the magistrate has in any way abused her discretion in setting this bond that was set in this case, or he or she. I'm not sure which magistrate said it. I think the circumstances, as the court understands the case at this point, is either stated by the defendant or filed in their written pleadings, would lead this court to that same conclusion, that in this instance of a open murder charge under these circumstances, that the defendant's bond should be denied. The court is not at this time going to change that bond. Defendant's motion for bond reduction or change of bond is denied in its entirety. Defendant's bond will remain denied. Thank you.
Oh, we have to set a date.
PCC or PE?
PE.
Judge, and I obviously would we don't have the autopsy protocol yet in this case. I know Dr. Tasha did it, and if we are bringing him in, he's not available till October.
Well, I mean, if that's the case, I think he should be entitled to a bond because it's not his purpose of delay in this matter.
Oh, then we can do this. It's Mr. Perkins, we can do this. If you want me to set it, they can start it, and then it can be adjourned for good cause. So which way do you want to do it? I mean, it's up to you.
Well, can we set a date? I'll go see my client. I saw him last night. Let's set a date sooner than later. And then if my client understands what I just don't think he understands what, I want to make sure he understands what we're doing. That's all.
So I'll set a preliminary exam date. I'll set that for August 15th, 2023. Pardon?
I'm just pulling up my calendar just to make sure I'm available now. Would that be a morning time, Your Honor?
Be a morning time, 9 a.m. before me.
Okay. All right, and I'll talk to him in the meantime and let Ms. Blanche know.
That will be in person. Thank you. Bond
Thank you.
continued is denied.
Thank you.
Thank you. That's it for us for today. All right. 14A stands adjourned. Thank you, folks.
Good morning, Your Honor. Kevin Callahan for plaintiff, P78273. I have with me the owner of the property, Abreet Kaur.
Good morning,
And
Your
this
Honor.
is
Robert.
go ahead.
I'm sorry, Your Honor. Good morning, Robert Bill here, Your Honor.
All right. Counsel, did you receive a copy of the answer?
We received a copy of the answer by email at 4:36 last night. It's my understanding from our last court date that Mr. Beal indicated that he was having his lawyer appear. No lawyer has appeared on the case. He was required to tender $10,000 into the court's escrow by the 10th of July. I don't have evidence of that. Not to say that it didn't happen. I don't have evidence of it. And he was required to answer the complaint by the 10th of July. And we just received the answer last night that poses zero legal defenses, Judge.
Mr. Beal, do you have an attorney here?
No, Steve Wallace will be hired as of next week. The reason I did not put the escrow in Monday as you required me to and give the answer, my business partner had a stroke in Oregon. I flew to Oregon and I just got back Thursday night. And my wife has already took the funds out the account. I didn't want her to take that a lot of money up there by herself. So I told her I'd start working on that after I speak with you today. But we have all of the rent money.
That escrow was supposed to be in.
Yes, Your Honor, you're right.
Oh, I know. And all right. And the answer was supposed to be in earlier than it is now. And I don't see where you're indicating that any defenses to the amount they're claiming is owed.
The amount they're claiming is owed, we're off a few $1,000s, but not the majority of the rent. The majority of the rent of the $4,500 is definitely due. I have been going back and forth with the management company to do some things around the house, and they have yet to do everything. But the key thing was the deck and the security of the deck. They told me we were going to put a deck up. They decided not to. I asked them to let me pay for the deck. Let me pay for the deck. They said, well, you pay for it. We're not going to reimburse you for it. I said, well, what about if I sell it to you back at 30% after I leave, after the lease is up? They said, no. I said, well, if I pay for the deck, can I take it with me when I leave? They said no. So I have been trying back and forth to go back and forth with them to try to work out an agreement with the deck. I did speak with the county yesterday, Steve, the inspector, and he said by law, they're not required to put a deck up, but they are required to have a security barrier back there. So Steve said he was going to call, Steve, the inspector for the county, said he was going to call email the owner to see if they can arrange to put a barrier up. Once that barrier is up, I'm fine. I don't have a problem.
How much is owing on this account?
With court cost, Judge, it's $18,944.23. Court costs are $235.
Here's what I'm going to do in this case is I'm going to, the escrow needs to be paid. Mr. Beal, we've been through this before. You always make promises to me in another case. You always make all these promises. There's some excuse, and you're just going to have to put up or not. I mean, I ordered $10,000 in escrow. You said you were going to pay it. I get here today. You didn't do it. I don't have any proof of what are the other things that you're talking about. Don't need it, quite frankly. You were supposed to put the $10,000 into escrow. So, if the escrow is, so I will grant the judgment. If the escrow is paid, then the judgment will not enter. It needs to be paid today. If the escrow is paid today by close of business, Then this matter adjourns out to July 21st, 2023 at what time? At 10 a.m. So the escrow needs to get there. If it's not here today, plaintiff's entitled to their judgment for their full amount. If it's there today, then I'll see you guys next week at 10.
Judge, if I may.
I make my orders, you got to follow.
Judge, if I may
Understood.
respond.
Pardon?
If I may respond to that, Judge.
Sure.
Judge, there's absolutely zero reason for us to adjourn this again. Mr. Beal,
Counsel,
at our second
counsel,
court date.
counsel.
If I could.
That is what I'm doing. I don't need a response from you. That is what I'm doing.
Judge, I would like to make a record if I could.
I go for it.
Thank you, Judge. At the second court date, we received a possession judgment for the full amount. Mr. Beal was not present. Mr. Beal decided to come later on, and the court set aside that judgment. At the subsequent hearing, Mr. Beal made promises to this court, made promises to us that he has a lawyer, he has the escrow, he has this, he has that. He didn't do anything he was required to, and there's zero legal defenses here. I don't understand why we are adjourning it again when there's absolutely zero legal defenses. If Mr. Beal has some kind of misunderstanding about.
Are you done? Are you done?
I'm not done, no, Judge. I'm trying to make my argument for the record.
Get done.
Thank you, Judge.
Get done.
Thank you, Judge. Any dispute about a deck is between the owner and the city and has nothing to do with the legal contract and has nothing to do with Mr. Beal's obligation to tender rent. I have an owner here that has been displaced from her house. She's owed over $18,000 and is not receiving a single dime here. I don't know why you're giving Mr. Beal another opportunity when there's absolutely zero legal defenses.
All right. First of all, part of your record is wrong. And absolutely wrong, because that was explained to you the last time. So don't try to distort the record, counsel. The reason that the judgment was set aside is Mr. Beal was attempting to try to get in. We verified it. In deference to somebody trying to sign into Zoom, I set aside the judgment. I explained that to you. So don't try to distort what happened. Second thing, I told Mr. Beal this is what he needed to do. He has given me some reason why he did not do it. Certainly, I question whether or not all of that occurred. But what I did is I said, look, if you were to put the escrow in, he files the answer, we'd have to deal with that anyway. He's saying there's a reason why he didn't put the escrow in. I'm giving him till today to get the escrow in. If the escrow's not in, you get your judgment. It's as simple as that. That's why that's happening. I'm done. Case over. We'll see you next week or not. Court calls case S&C Holdings versus James Smith.
Your Honor. Good morning, Your Honor. Tracy Thomas appearing on behalf of the plaintiff.
Mr. Smith, can you state your name, please?
James Smith, Your Honor.
All right. You guys want to fight with me too?
Absolutely not, Judge.
No. Let's roll. I'm ready today.
I'd like to make a record.
No.
Everybody's asking me why I'm doing what I'm doing. I'm doing this 23 years and I get questioned today. Anyway, go ahead.